Good evening and good Chodesh. It is still Rosh Chodesh, the first day of Sivan, a wonderful month that includes Shavuos, when we celebrate the giving of Torah at Mount Sinai, and that holiday begins Thursday night. So it's the final countdown to that very special day in the calendar, and today is the first of the Hebrew month of Sivan. Rosh Chodesh is on the 6th, yes. Why does that not seem to add up right? Well, it's definitely Rosh Chodesh. It's definitely Rosh Chodesh. Yeah, right. Today's day 1, and day 6 would be Friday, which begins Thursday night. Awesome. Let's light up the darkness. It's also the month with my Hebrew birthday in it on Sivan 16. Who's in the house? Paul in the Great Northwest, Shandor in the Bronx, Paula in Minneapolis, Belle in Texas, Bella in Florida, Sharon in New Jersey, Elvis in New York, Nancy, North Carolina, Bill in mid-Missouri, Melissa in Great Neck, Lucy in Minnesota, John in Maine, Joe in the Inland Empire, Gosia in Chicago, Stephen in New Hampshire. Wait, that just came in. And Paul is paying attention closely. And you and Nina have plans tonight. Yes, we're going to go to the LA Jewish Film Festival and see a movie directed by a good friend of ours, Matthew Mashori, called Who Are the Marcuses, about a very unassuming couple who lived a very modest life, but who invested in Warren Buffett's company, Berkshire Hathaway, like at the very beginning. So no one even knew they were rich when they died or near the end of their lives. I'm not sure. I don't know that much about the movie, but they donated $500 million to a university in Israel. So this is a documentary about who are they? Who are the Marcuses? Very curious to see that. Welcoming also Ella, Marjorie in Georgia, Gwen saying good evening, Aoife in Florida. Welcome everybody. All right, because we got to get to that screening, and it's kind of halfway across town, and it begins at 7, which is in 56 minutes. Luckily, we have a pretty short daf tonight, so let's get moving. We're in Tractate Gittin, the 19th volume of the Talmud, chapter 1, Mishna 1. Our daf is Gimel, page 3. Continuing our discussion of Mishnah number 1, which said that if a husband is overseas, he sends a get, a bill of divorce, to his wife in the land of Israel. The sages declared that the agent who brings that get has to declare when he's giving it to her there in the land of Israel, that the bill of divorce was written in his presence and signed in his presence. Now, Rabbah and Rava have a dispute about the reasoning why the sages declared that. Now, remember, the agent is just the delivery person. The get was properly written in front of 2 witnesses by the husband. He's just being sent by this agent. He's the delivery man. But the sages said that this agent actually has to be somebody who was present when the get was written and when it was signed. And remember, very important, that when a get is written, it has to be particular to that couple. They can't use a get that was written by somebody else who had the same names, husband and wife. They can't use one that was used as a teaching example. It has to be written by the husband for this particular wife. Now, Rava said the reason the sages decreed that the agent has to declare it was written in my presence and signed in my presence is because scribes outside of the land of Israel might not know this law that the get has to be written by that husband for this wife. And because they're not expert in that, we need this additional safeguard. And Rabbah disagrees, and he says the reason that the sages decreed that the agent has to make that declaration is because the witnesses who saw, who witnessed the writing and signing of the get out abroad are not present in Israel, and that's why we need this additional safeguard. All right, we pick this up near the top of page 3a. Now, the Gemara answers, since the master says, in the presence of how many people must the agent who brings the bill of divorce give it to the woman? Rabbi Yochanan and Rabbi Hanina disagreed with regard to this issue. One said that he must deliver it to her in the presence of at least two people, two witnesses. And one said, no, he must deliver it to her in the presence of at least three people. Why? Because three individuals are considered a court. Right? So in other words, it's going to be an official, remember, when that gets delivered to her, at that moment, she's divorced. Right? So that is a judicial procedure, as it were. And so at least according to the opinion of Rabbi Hanina, that should be witnessed by three people as if it's being done in a court. These people become the court in which it's being done. Of course. So therefore, at the outset, the agent is careful to clarify the matter fully, and he will not act to his own detriment by bringing an invalid bill of divorce. Now, the Gemara asks, and according to the opinion of Rava, who said that the agent must say it was written in my presence and it was signed in my presence, because there are no witnesses available here, right, at the other end of that journey that the agent took, right, he saw that it was written and signed in his presence, the agent's presence, and at that time there were two witnesses at least. He might be one of them, but there were at least two witnesses. Now, those witnesses are not going to be available at the time that the get is delivered, right? So according to the opinion of Rava, who said that the reason the agent must make that declaration, it was signed in my presence, it was written in my presence, is because the witnesses, the other witnesses, won't be here at the time that the get is delivered. So, according to the opinion of Rava, let us require two witnesses, just as is the practice with regard to the typical case of ratification of legal documents, which must be performed via two witnesses. And the Gemara answers, as above, one witness is deemed credible with regard to prohibitions, right? And the Gemara will explain again just what I explained yesterday. And so again, the Gemara asks, one can say that we say that one witness is deemed credible with regard to prohibitions in a case such as where there is a piece of fat, and it is uncertain whether it is forbidden fat, and it is uncertain if it is permitted fat. In other words, if it's kosher to eat or not. So in this situation, the piece can be permitted by a single witness, as there is no presumption that it is forbidden. We don't know. We have no reason to suspect that, we have no reason to assume that that fat is forbidden fat. We just don't know. So if one witness comes and says, no, I saw that piece of fat is permitted. It's a kosher piece of fat. It is permitted to be eaten. We can rely on that. But in the case of this woman who is married and is going to become divorced, so while she's married, she's prohibited to go, marry any other man in the world. The divorce is going to render her permitted. She's going to be allowed to go marry some other man. But if she relies, on one witness for this, it's no good, because if that witness turns out to be wrong or lying, she doesn't have a valid reason to assume that the get is valid, right? So when she remarries without the proper two witnesses attesting that it was valid, So, she remarries. It's an illegitimate marriage. And if they have children, the child is a mamzer. That's a terrible, terrible outcome. So that's why we would assume, it's a halakha, law, that in terms of forbidden sexual relationships, we can only move forward on the testimony of two witnesses. We would never rely on a single witness in such a case. And isn't this such a case? Right? In this situation, the peace can be permitted by a single witness for the permitted or prohibited fact. But, however, here, in the case of the get, there is a presumption that this woman is forbidden as a married woman. So if so, this is a matter of forbidden sexual relations, and there is no matter of testimony for forbidden relations that can be attested to by fewer than two witnesses. And the Gemara answers, by right, it should be that with regard to the ratification of legal documents as well, the court should not require two witnesses in accordance with the opinion of Reish Lakish. Because Reish Lakish says witnesses signed on a legal document become like a pair of witnesses whose testimony has been examined in court, and the document should be accepted without further ratification. In other words, when the husband wrote the get, there were witnesses to that, and they signed their names on the get. The agent who's delivering the get is simply saying, I saw it. I saw that it was written in my presence. It was signed in my presence. I saw two witnesses sign that. Are we going to keep multiplying witnesses? That we need two witnesses to attest that they saw two witnesses sign the document? It starts to get out of hand. Reish Lakish is saying, you need two witnesses. Absolutely, you need two witnesses. There were two witnesses. They signed the document. Are we also going to need two witnesses to ratify that those are the signatures of the two witnesses? That's not necessary, says Reish Lakish. Witnesses signing on a legal document become like a pair of witnesses whose testimony has been examined in court, and the document should be accepted without further ratification. And it is the sages, in other words, the majority who disagreed with Reish Lakish, who required the court to ratify documents. And here, with regard to bills of divorce, the rabbis were lenient with her by allowing the document to be ratified through the agent's testimony alone due to the possibility of desertion. So we're going to require ratification, or at least ratification if the husband comes and challenges that he never wrote that get. Or maybe we're going to require ratification always. But ratification, it's not going to require two more witnesses on top of the two witnesses who were there when the get was signed. Right? Ratification is not a whole other level that requires two witnesses. One witness will do. And furthermore, it's important that one witness will do, because if you're not going to be able to accept that get without either the two witnesses who were there when the get was signed, or two other witnesses who can ratify that those are the signatures of the original two witnesses, she might end up never being able to get that divorce, right? And the husband might have sent the divorce and then disappeared. Now, the divorce should be a valid divorce, but if we're going to put all these hurdles in the way of having the divorce accepted, so she's never going to be free to remarry. So this is a leniency to her benefit, that we only need, one agent or one witness to ratify the signatures. But the Gemara challenges this and says, is this ruling a leniency? It is a stringency, since if you require two witnesses to testify with regard to the bill of divorce, then her husband cannot come to contest and invalidate it. Whereas if there is only one agent, her husband can come and contest and invalidate it. So once again, the Gemara answers, since the master says, in the presence of how many people must the agent who brings the bill of divorce give it to the woman? And Rabbi Yochanan and Rabbi Hanina disagreed with regard to this issue. One said that he delivers it in the presence of two witnesses, and the other says he delivers it in the presence of three because they constitute a court. Therefore, at the outset, the agent is careful to clarify the matter. In other words, they don't require two witnesses to attest that that there were two witnesses. One will do, but this one, the agent who's delivering the get, he's going to deliver it in the presence of two witnesses. So at least we have two witnesses overseas that the husband signed, and we have two witnesses in the land of Israel that the get was delivered to her, or maybe even three. But what we don't need is that it's two are traveling from overseas to here. After clarifying the basic dispute, it's not so basic, but hopefully we're following it, the Gemara discusses the reasons for each opinion. All right, now back to the dispute between Rava, who said the sages decreed that this agent must say, it was signed in my presence, it was written in my presence. Why, says Rava? Because scribes overseas are not necessarily expert in this requirement, in this law, that it be written specifically for her sake. And Rava says the reason the sages decreed that the agent must make that declaration is because the witnesses overseas are not available here. Okay, keep that in mind. So now the Gemara discusses this difference. And as for Rava, what is the reason that he did not say, like Rava, that the reason the agent must declare it was written in my presence and signed in my presence is due to the concern that the bill of divorce was not written for the woman's sake, right? Why is Rava not concerned about that? And the Gemara answers that Rava could have said to you, is it taught in the Mishna that the agent must say it was written in my presence for her sake, and it was signed in my presence for her sake? Since the agent does not have to testify that it was written for her sake, this indicates that the sages did not institute the requirement that he state this declaration in order to ensure that it was written for her sake. So says Rav, it must be that the reason they instituted it is because the witnesses overseas are not available here. And the Gemara asks, so how does Rabbah respond to this claim? And the Gemara answers, well, by right, it is so that the Mishnah should teach in this manner, that it was written for her sake, and that the agent should have to declare it was written in my presence for her sake. However, the sages didn't go that far and require the agent to say this, because if you increase the agent's requirement to speak by obligating him to state this lengthy declaration, he will likely come to shorten it. And if he has too much to remember, he might forget some of the formula, and his error will render the bill of divorce invalid. So they're not going to overcomplicate the issue. So the Gemara asks, now too, with regard to the formula, as it stands, it was written in my presence, it was signed in my presence. Maybe he'll come to shorten that also by omitting either that it was written in his presence or that it was signed in his presence. So you're saying that if he shortens the declaration, doesn't make the full declaration, now it's not a valid bill of divorce? And the Gemara answers, the agent is likely to shorten it by omitting one term out of three, such as for her sake, from the three-term clause, it was written in my presence for her sake. However, he will not come to shorten his declaration by omitting half of it, by omitting one term out of two. Consequently, when asked if it was written in his presence, he will answer with the full statement, and the same is true when he is asked if it was signed in his presence. Now, the Gemara asks concerning the other opinion, and as for Rabbah, what is the reason that he did not say like Rava, that the reason for the decree is because witnesses may not be available to ratify the bill of divorce? And the Gemara answers that Rabbah could have said to you, if so, let the Mishnah teach, it was signed in my presence, and nothing more, as this is a confirmation that the signatures of the witnesses on the document are valid. Why do I need the agent to add, it was written in my presence, right? That the get was drafted in my presence? Why do we make him say that as well as it was signed in my presence? Conclude from it that the reason for this decree is because we need the bill of divorce to be written for her sake, as Rabbah maintains. So the Gemara asks, and how does Rabbah respond to this claim? And the Gemara answers, Rabbah would answer that by right, it is so that the Mishnah should teach it in this manner. But if this were to be so, that the agent declares merely, it was signed in my presence, people will come to confuse the matter with the typical case of ratification of legal documents. In other words, they will think it is possible to ratify other documents via the testimony of one witness. This is a special case that we only allow the ratification of the signatures via one witness in the case of a get that comes from overseas. It's not the case for other areas of the law. Consequently, the sages added that the agent must also declare it was written in my presence, which is not generally stated with regard to the confirmation of other documents, and serves to put everyone on notice that, hey, we're talking about a get that's a different area of law than if we were talking about other kinds of contracts. So the Gemara comments, and Rabbah would respond as follows: there is no concern that people will confuse the ratification of a bill of divorce with the typical case of the ratification of legal documents, as are these two cases comparable at all? There, with regard to the ratification of other documents, the witnesses need only say, we know that these are the signatures of the witnesses on the document. By contrast, here in the case of a bill of divorce, the agent must say, it was signed in my presence, right? When you're ratifying signatures on a contract, you don't necessarily have the benefit of a witness who was there when the witnesses signed the document. Right? You might have an expert in signatures, or you might have somebody who is familiar with the particular signature of the husband or of the other witnesses at the time that the get was written, who can say, I recognize that signature. That's definitely the signature of so-and-so. So it's enough to say we know the signature. But for a get delivered from overseas, the agent actually has to be able to say truthfully, that get was written in my presence and it was signed in my presence. That's quite different than I recognize the signature. So this is only the case in the law of the get, not other documents when they are ratified, when those signatures are ratified. Additionally, there in the case of other documents, a woman is not deemed credible, whereas here, a woman is deemed credible when she brings a bill of divorce and declares that it was written and signed in her presence, right? A woman can act as the agent who brings it in from overseas and is deemed credible to give testimony in a rabbinic court that it was written in her presence and signed in her presence. It's just a feature of ancient, Talmudic and Torah law. That women's testimony was not considered sufficient generally, although as we've seen, there's many cases where women's testimony is considered valid and sufficient. And Rava, how would he respond to this claim? He would have said to you, is that to say that here in the case of a bill of divorce, if the witnesses of ratification say, we know that this is a valid signature of so-and-so, that they are not deemed credible? They would be deemed credible even if they used that formula. And since when they say, we know that that is the valid signature, they are deemed credible, so people will come to confuse it with the typical case of ratification of legal documents, which they will perform via one witness, which is not normally done. And the Gemara asks, and according to the opinion of Rabbah, who said that the reason for the declaration, it was written in my presence and it was signed in my presence, is because they are not experts in writing a bill of divorce for her sake, these scribes outside the land of Israel. Who is this Tana? Who is this rabbi of the Mishnah who requires that the writing of the bill of divorce must be performed for her sake, and also requires that the signing must be performed for her sake? If it is in accordance with the opinion of Rabbi Meir, he requires signing for her sake. However, he does not require that the writing must be for her sake. Now we're on 3b. Rabbi Meir would say, well, that get has to be signed by that husband for this woman. But Rabbi Meir does not require that the get was originally written for her sake. You know, if you had a get lying around that didn't get used or was not currently being used, and it contained the same names of the husband and the wife, and then the husband just wants to use that get to divorce his wife, Rabbi Meir would allow it as long as this particular husband signed it and sent it to that particular wife. Now that's a minority opinion, it's not the law. But with regard to Rabbi Meir's opinion, as we learned in a Mishna on page 21b of this tractate, one may not write a bill of divorce on anything that is attached to the ground. For example, a leaf attached to a tree. However, if he wrote it on something that is attached to the ground, and then he detached it, signed it, and gave it to her, it is a valid get. And this indicates that the essential stage of writing a bill of divorce is when it is signed by witnesses. And the Gemara says that this is Rabbi Meir's opinion, as an unattributed ruling in the Mishnah typically follows the opinion of Rabbi Meir. If it is in accordance with the opinion of Rabbi Elazar, who disagrees with Rabbi Meir, and requires that the writing of the get must be for the sake of this particular woman, so he does not require that the signing must be for her sake. And if you would say that actually the Mishnah is in accordance with the opinion of Rabbi Elazar, and when Rabbi Elazar does not require signing for her sake, he means by Torah law. Whereas by rabbinic law, yes, of course, we require that bills of divorce must be signed for the sake of the particular woman. But that argument is untenable, as the sages listed 3 bills of divorce, we're going to counter this law on page 86 of this tractate, that are valid by Torah law, but are invalid by rabbinic law. And when he disputes that ruling, Rabbi Elazar does not require that the signing must be for her sake. As we learned in that Mishna on page 86a, 3 bills of divorce are invalid ab initio. But if the woman married another man after having received one of these bills of divorce, the offspring is of unflawed lineage. In other words, the get was written wrong. It was a wrong get, right? It was a flawed get. But the flaw was small enough that if the woman relied on that get and remarried and had children, we're not going to declare that the second marriage is invalid or that the children of that marriage are mamzers. We don't do that, right? It's a flaw in the get that should not happen, but if it did happen, we're not going to declare the subsequent marriage invalid. And what are these bills of divorce that are flawed, but still, if the woman relied on them, her second marriage is valid? Number 1, a bill of divorce that the husband wrote in his handwriting, but there are no signatures of witnesses on the document. No witnesses. And if there are signatures of witnesses on the document, but there is no date written on it, that's the second case. And the third case, and if there is a date written on it, but it has only one witness signed on it. These are the 3 invalid bills of divorce concerning which the sages ruled, and if she married, the offspring is of unflawed lineage, right? She shouldn't have relied on it, but she did. And if she did, we're not going to penalize her second husband and the children of that union. Now the Mishnah continues. So Rabbi Elazar says, right, now we're just setting the stage here for the argument. So Rabbi Elazar says, even though there are no signatures of witnesses on the document, but he gave it to her in the presence of 2 witnesses, so then it is a valid bill of divorce, right? So it shouldn't have been done that way, but if it was done that way, a get was given in the handwriting of the husband, no witnesses are signed on the get when the husband wrote it, but it's in his handwriting and it was given to her in the presence of 2 witnesses. So then, we're going to say the second marriage is valid according to Rabbi Elazar, right? So that's even with no witnesses signing the get. And on the basis of this bill of divorce, the woman can collect the amount written into her marriage contract from the first marriage, even from liened property. As Rabbi Elazar maintains, that witnesses sign the bill of divorce only for the betterment of the world. If no witnesses sign a bill of divorce, the husband could contest its validity at any time by denying that he wrote it. In any case, it can be seen from this Mishnah that according to Rabbi Elazar, the signatures of the witnesses are not an essential part of a bill of divorce by Rabbi Elazar. Consequently, it does not need to be signed for her sake, even by rabbinic law. But rather, you can say that the Mishnah is in accordance with the opinion of Rabbi Meir. And when Rabbi Meir does not require that the writing must be for her sake, he meant by Torah law. Whereas by rabbinic law, he does require that the writing be for her sake. However, the Gemara raises a difficulty against this explanation as well. But didn't Rav Nachman say that Rabbi Meir would say a bill of divorce need not be written for her sake? And even if a husband found the bill of divorce in the garbage, and the names of the man and the woman on the bill of divorce were the same as his name and that of his wife, and he signed it and gave it to his wife, it is a valid bill of divorce. And if you would say that we learned that this statement of Rav Nachman applies only by Torah law, whereas by rabbinic law, Rabbi Meir concedes that a bill of divorce must be written for her sake, if so, Rav Nachman should have said, Rabbi Meir would say that by Torah law, if a husband found the document in the garbage, he may use it. So rather, the Gemara I'm almost done. So if you have any questions, I can take like 1 or 2. Get them in. The Gemara retracts the previous answer and states, actually, the Mishnah is in accordance with the opinion of Rabbi Elazar. And when does Rabbi Elazar not require that the signing must be for her sake? When there are no witnesses at all on the bill of divorce. However, where there are witnesses, he does require that all their signatures must be for her sake. And the proof for this is that Rabbi Abba says, Rabbi Elazar concedes with regard to a document whose falsification is inherent in it, i.e. a document that is signed by a disqualified witness, that it is invalid. And this shows that although Rabbi Elazar maintains that a lack of signatures does not necessarily invalidate a bill of divorce, all signatures included in the bill of divorce must be valid, otherwise the document is rendered invalid. So we still haven't figured out where we come out in this dispute between Rava and Rabba on the motivation for the sages when they declared that the agent must declare it was written in my presence, it was signed in my presence, and what the practical significance is going to be when ratifying the signatures is the challenge. That's an oversimplification of what we're talking about. But this is a good challenge that we have encountered here on page 3 of Tractate Gittin. Okay, let me just see if I can take a question, one or two questions quickly. And of course, Google Docs signed me out, and I need to sign back in. Wouldn't it be the case just when I'm in a big hurry? Tom Beck says, if the husband personally gives the get to his wife, isn't it automatically valid? So we're definitely talking about the case where the get was sent from overseas. Now, if the husband gives the wife the get, much simpler case. But don't we need witnesses to the giving of the get, right? Because otherwise, the husband could later come and say, I never gave her a get. Right? I never gave her a get. She falsified that get. I don't know where that get came from, right? So, I mean, those kinds of questions we're only peripherally encountering now, which would seem to be the more basic questions, but the Talmud is always like that. We jump to a bigger, more tougher, complicated case, and then later we'll start to establish the ground rules of what's the simple case of a valid get and what are the simple requirements of a valid get. But we'll come back around to that. That's what I've got for us today, and with God's help, we'll be together again tomorrow night.